Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. This is ethics class. In this video, we are going to discuss the development of the legal profession in India. Friends, you all know that the legal profession was not as well organized as it is today before the pre-British period. But don't think that there was no legal profession before English period. It was there in Mughal emperor's time. Even in our ancient times, like a king. King was the ruler. King was the incarnation of God. Whatever king says, yes, it has to be obliged. Like this, slowly, from the ancient kings, then Muslims, then Mughal rulers, then British entered. But of course, we have to say that the British have streamlined or they have codified the legal profession, and now we are following the legal profession in a systematic manner as per the Advocates Act 1961. Please remember, the legal profession plays an important role in the administration of justice because the lawyer assists the judge in arriving at the correct judgment. In the case of Madhav Singh, that is AIR 1923, patent number 185, page number 185. So, Madhav Singh, the court has observed that advocates and pleaders, they are enrolled not only for the purpose of rendering assistance to the court in the administration of justice, but also for giving professional advice for which they are entitled to be paid. So, dual role. That is the importance of the legal profession, right? So, please remember, actually, they have to have the high principles of professional conduct because, legal profession is the noblest or noble profession. So, how this has emanated? So, please remember, let us have a quick glance towards the development. Of course, ancient period, what happened? Our caste elders or group elders, heads of the people, they used to sit in the open sky and they used to deliver judgment. That's all. No vakil, nothing was there. That is the ancient period. During the medieval period, please remember, medieval period. So, when the Mughal emperors were there, please remember, so the emperors employed certain people called as vakils. The concept of vakils have come in that particular time because the Mughal emperors, they came from Persia. They do not know our language. So these vakils used to represent the people and get a percentage out of the suit. They used to get a percentage. Actually, they worked as the representatives of the Mughal emperors. So that's why the vakil concept of vakil has come. So you may be knowing in the period of the famous Akbar, Babur, Humayun or the Shah Jahan, all these times, Diwani Am, Diwani Khas, Sadar Diwani Adalat, all these courts, they have existed, and with the vakils, they have been continued. Already I told you before that the king's court, king used to hold the court on one day in a week, then he used to hear the version of the complainant, then he used to call the defendant, he used to hear the version, then he used to consult the Council of Ministers, used to take their advice. Of course, there is no bar that he has to take their advice. Then he used to deliver the judgment. Then came the Britishers. Please remember, during British period, the law as it is today was developed and actually created and developed like this. So, the first charter is, please remember, 1726. Actually, this charter is the first charter which has allowed or which has created 3 courts. They are called as Mayor Court, Mayor's Courts in India. The first 1726 charter, so Mayor's Courts in Presidency towns. You may be knowing, Presidency town means Chennai, that is Calcutta and Bombay. So it is a beginning of new era. mayor courts, they used to dispose the civil suits and actually yes, they used to dispute civil. Actually, there is no separate criminal cases at that particular time. For the settlement of the company's matters, all these things, mayor's courts were established. Then, who were allowed to practice? Only the barristers. Who are the barristers? The barristers are the advocates who studied bar at law in England. They were allowed in the mayor courts. Slowly, please remember, by 1773, so 1773, the Regulating Act has come. Ultimately, in the year 1774, you may be knowing, the Supreme Court was established at Calcutta. Now, the legal profession has taken its clear shape. So, here, with the establishment of the Supreme Court at Calcutta, they used to call it as Imperial Court. It was given the powers to enroll and approve the advocates. 1774, they did not make legal training. No legal training and no qualification, but they used to enroll and approve the candidate. People like Wakils, Mughals and pleaders, they used to get enrolled. Only number was given. Okay. Then came, of course, 1774 we have discussed. Then we'll go to, next is, before that, please remember, Bengal Regulation Act has come, 1793. So, this has given rise to a regular practice in the company's court. But only Hindus and Muslims, they were entitled. Right? Then, the first, you may be knowing, the first advocate, male advocate, of course, he is from England, who studied bar at law, and he is Manmohan Ghosh, the first male advocate. Then he got registered in 1844 and he was there up to 1896 or so. For about 50 years he has practiced. Then in 1846, an act called as the Legal Practitioners Act. So, present Advocates Act, this is the genesis. Legal Practitioners Act, it has come into existence in 1846. So here it is clearly established that the advocates and wakils, they can practice, and muqtars, this scheme was avoided. And in 1897, woman advocate Cornelia Sorabji, she was given the so-called enrollment. Of course, lot of amendments. Actually, in 1923, an amendment has also come. So, no woman should not be allowed, not be allowed because of the that is discrimination on the sex. So, basing on that, she also started practicing, right? And later, in the year 1923, so, remember 1923, the so-called Indian Bar Committee. An Indian Bar Committee was established to study the situation, to streamline the law relating to the lawyers and other things, what to do. So this All India Indian Bar Committee, they have given certain recommendations. So basing on the recommendations, in 1926, that is after 3 years, Indian Bar Councils Act has come into existence. But this Bar Councils Act, it has admitted even non-barrister advocates also. Here, now Indians, they are coming into. Previously, Hindu and Muslims were allowed, please remember, in that particular case, only Hindu and Muslims were allowed. Previously, that too, they must be studying in bar at law or Oxford. Now, please remember, with this, actually, 1926 Act, Indian Bar Councils Act, it has permitted non-barrister advocates also. That means the LLB course has totally come into existence. Here, please don't forget the name of Dr. N.R. Madhav Menon, who has formulated the syllabus for LLB. Right? 1926, the Act, Indian Bar Councils Act come. That is the first step for the All India Bar Council. Later, 1951, so after independence, 1951, All India Bar Committee. So, in this committee, they have said that the Mukhtar and the pleader, so they should not be under scope of 1926 Act. Anyway, so they are wakils, the so-called practice of pleader and Mukhtar, they were given away with. Please remember, no further recruitment of non-graduates also. So now they have to prepare a common role for all the advocates. So almost we are coming to the end. Indian Bar Committee's recommendations, 1951. So legal profession after independence. So an All India Bar Committee was appointed under the chairmanship of Justice S.R. Das, who has formulated the so-called Act of 1951, All India Bar Committee. The committee recommended the establishment of an All India Bar Council and state bar councils. This is the very good recommendation made by Sri S.R. Das, establishment of All India Bar. So ultimately, so with this they have formed an act called as the Advocates Act 1961, which we are going to study in this particular semester. So the present Advocates Act was enacted in the year 1961. So please remember, the very purpose of enacting the act is, please remember, for amending and consolidating the law relating to the legal practitioners. The law relating to the legal practitioners, it is consolidated, it is amended and almost codified, I can say. And another advantage for providing bar councils at the level of state as well as at the level of Union of India, Bar Council of India as well as Bar Council of a state. So now we are following the Advocates Act 1961, which enrolls, according to which the enrollment procedure, the admission procedure, the if there is any misconduct, the punishment procedure. So how to behave in the court, the rules making procedure, all these things are being continued under the Advocates Act 1961. I think it's getting more than enough time. Therefore, I am stopping here. Please actually formulate year by year. So first 1723, then 1726, then 1773, then 1774, then 1793, then 1844, 1846, 1923, 1926, 1951 and ultimately 1961. If you note down first of all the years, then opposite to that some bullet points you can make and you can remember. Otherwise difficult for understanding. Okay, with this I am concluding. Thank you very much.